Hey folks, welcome to today's episode of Law of Self-Defense. I am, of course, attorney Andrew Branca for Law of Self-Defense. Make yourselves a little bit of helmet hair today. Rode the bike into work today. Thanks for coming in. Make yourselves comfortable. We are here, of course, to talk once again about Andrew Lester and the shooting of Ralph Yarl. Let's see if this is... Make sure everything is streaming the way it's supposed to be. Rumble looks good. YouTube looks good. And yes. I don't know. Twitter? What's going on with Twitter? There we go. Twitter's working. And finally, but most important, and the Law of Self-Defense member stream is working as well. So I'm going to share some actual law with all of you today, specifically Missouri statutes and a pivotal Missouri Supreme Court decision handed down less than a year ago. That is the decisive Missouri law on the shooting of Ralph Yarl by Andrew Lester. And it certainly provides a justification for the shooting, at least the first shot. There's a little factual dispute about the second shot. We'll get to that when we get to that. Right now, make yourselves comfortable. We got a bunch of actual law and stopping the cap, dismissing. I'm seeing a lot of attorneys being interviewed by the public media who've obviously done no legal research here, have no understanding, are providing legal insights that are purely emotional, what they'd like the law to be. And of course, as all of you know, in the law of self-defense community, that's a bad way to do legal analysis, getting your emotions involved in it. Here we do evidence and law. Now, there are some disputes about the evidence, so we have to take that into account. But the law here is pretty clear and pretty clearly in favor of Andrew Lester. Again, at least with respect to that first shot. So throughout the today's show, if you'd like to pose any questions or any comments that you'd like me to address personally, the best way to do that is to be a Law of Self-Defense member, because then it's free. On the member dashboard, ask as many questions as you want, as many comments, and there's no charge at all. Of course, that's just part of being a member. And the good thing is membership is dirt cheap. It's about 30 cents a day, folks, to be a Law of Self-Defense member. You can join right now for today's show at lawofselfdefense.com/join. It's less than $10 a month, and you get to ask an infinite number of questions from me. I do ask that if you're putting your questions in the member dashboard, please preface them with the word question in all caps so they're easy for me to see. In the unfortunate event that for whatever insane reason, you'd rather not ask questions for free, but pay, you can do that too, I guess. On YouTube, they would need to be $5 minimum super chats. And on Rumble, they need to be $5 minimum Rumble rants. And I'll answer those questions as well. Seems silly to pay $5 a question when for $10 a month, you can get all your questions answered for free, but I leave that up to your discretion. For those of you thinking straight today, again, you can become a Law of Self-Defense member right now by pointing your browser, open another tab, go to lawofselfdefense.com/join, and there you are. By the way, we're also only doing the actual shooting analysis videos, because every time we do those on YouTube, we get struck by YouTube. We get demonetized. They punish us. They punish us in the algorithm. So moving forward, any shooting related stuff, and we have a couple videos spooled up, will be done only for Law of Self-Defense members. So if you're interested in actual legal analysis of actual use of force events in which people are shot, you need to be a Law of Self-Defense member to get that analysis from us. So another reason to join at lawofselfdefense.com/join. And before we jump completely into the substance of today's show, I should mention our sponsor, which is none other than Law of Self-Defense, American Law Courses. This is our series of law school level courses, the same courses that every prospective lawyer takes in their first year of law school, things like criminal law, evidence, property. And this summer, the summer semester, is our first course on constitutional law. We have a whole series of these law school level courses for people who want to be the best informed American citizens they can be by really understanding the law at a law school level without anything like the cost or time commitment of law school, and perhaps most importantly, without the political toxicity of today's law schools. These courses are, each time we run a course, it's taught live, and then the playback version of that course is also made available to students. Again, we have 5 or 6 or 7 courses already spooled up in the curriculum. Constitutional law for the summer semester being taught live. If you'd like to learn more, just point your browser to AmericanLawCourses.com. AmericanLawCourses.com. Okay, so what prompted today's show? Well, it was really this terrible reporting I'm seeing in which lawyers, purported lawyers, are being asked for their insights, their legal insights into this case, and providing the least informed, least competent legal insights that you could imagine. Now, that's not uncommon in these high-profile, politically charged, racially charged, although there's no evidence of any racial element here, other than the happenstance of the people's skin color involved. But in these politically charged, racially charged cases, the media, of course, wants to reach out. They have to write about something every day. They're going to write about this case. They'll reach out to lawyers. Unfortunately, the lawyers, for the most part, are incredibly ill-informed on use of force law. Don't bother to do any research. They're just going to talk for 3 or 4 minutes to the journalist, get their quotes in the paper, and everybody's happy. Except, unfortunately, for the readers who are badly misinformed about these cases. This is why people are outraged. Much of the public is outraged when they hear that George Zimmerman was acquitted or Kyle Rittenhouse was acquitted, because the public's been lied to. They've been lied to for a year and a half preceding these trials, preceding these verdicts. They're lied to about the evidence. They're lied to about the law. And if you're lied to for such a long period of time and you believe the lies to be true, of course you're outraged by the acquittals. I would be outraged by the acquittals too if I believed all those lies. And that's why we exist here at Law Self-Defense, is to tell you the actual truth, the truth of the evidence as we best know it, and the truth of the law as we can show it to you from the actual sources of law, statutes, court decisions, jury instructions. And we show you the receipts, folks. That's how we do it here. All right, so there was this article. Let me see. Let me line all this up. Did I open it up here? I have it. I was just looking at it. Okay, here it is. Now, folks, I do put these articles into a Word document form because when I try to show them from the web page itself, it runs all ads all over it, and it's very distracting. But I do include the links, and I'll put the links for all of these in the description of today's show, so you can go look at the articles yourself if you want to confirm that I'm not altering anything. But I came across this article from Newsweek, headlined "Ralph Yarl shooter using stand your ground defense is nearly impossible in quotes. And the first paragraph here I've highlighted: it will be extremely difficult for the man who shot 16-year-old Ralph Yarl to mount a successful defense under Missouri's stand your ground law. Legal experts told Newsweek. Experts, legal experts, indeed, legal experts who think Missouri's got a stand your ground law that you would raise as a legal defense to contest a use of force criminal charge. There's no such thing, folks. Stand your ground's a policy, a doctrine. All stand your ground does is relieve you of an otherwise existing duty to retreat. What they should be talking about here is Missouri's self-defense law. and defense of highly defensible property law. Those are legal defenses. But there's no stand your ground statute. The stand your ground language that relieves you of an otherwise existing duty to retreat is woven through the self-defense statute. It's a self-defense law, not a stand your ground law. And in any case, even if Missouri was not a stand your ground state, like 38 other states, by far the majority position in the US, this event occurred in and around Andrew Lester's home. Even if Missouri insanely imposed a legal duty to retreat in otherwise lawful cases of self-defense, Andrew Lester would be relieved of that duty regardless because he's in his home. And the castle doctrine would apply, relieving you of an otherwise existing duty to retreat if you're defending yourself in your castle. So right away, I can tell these purported legal experts have no idea what they're talking about, and that it only gets worse as we dig through the rest of the article and they're actually quoted. And we'll share the quotes and share their names because they said these things and desired it to be published for the public to read. So we'll take a closer look at that in a moment, their specific quotes. I do first, however, want to take another look at the relevant statute here. Let me bump that up. Remember, folks, if you want me to address your comments or questions, they need to be either in the Law Self-Defense member chat or you have to pay. So I see these various people shouting in all caps. I just ignore it, folks. If you want me to address it, pay $5. That's how that works. Okay, so the relevant statute here in Missouri is section 563031, use of force in defense of persons. And it happens to address the statute, both defensive persons and the use of deadly force in defense of highly defensible property, which in this context applies to your dwelling, your residence, your vehicle. And when we talk about defensive persons, first, talking about defensive persons, that's one way that you can be justified in using deadly defensive force. First, you have to meet all the conditions for using non-deadly force in self-defense, and then there are additional conditions for using deadly force in self-defense. Now, collectively, these conditions are what I refer to as the 5 elements of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness, meaning that you must have been the innocent victim of an imminent, unlawful act of force, deadly force, if you're using deadly defensive force. And you must have reasonably perceived what was going on. You were not having an irrational, panicked, imaginary fear of harm. A reasonable person in your circumstances would have shared your genuine subjective fear of harm and the need to act in self-defense. Now, of these elements, of course, avoidance is not required here because, first of all, Lester was in his home, so castle doctrine would apply, even if he would have had a legal duty to retreat outside his home. But in any case, Missouri is a stand your ground state, so he wouldn't have had a legal duty to retreat even outside his home. So we're really only talking about 4 elements that Lester has to satisfy if he were arguing defense of himself, self-defense. And he may well raise that legal defense. But those elements would be that he was the innocent victim of an imminent, unlawful, deadly force attack, and he had a genuine belief that was the case, and that belief was objectively reasonable. Now, if that were his only legal defense, one might argue that, well, it's not clear that Ralph Yarl was presenting as a deadly force threat. Ralph Yarl didn't have a weapon, for example. I would argue the defense is still viable because we have a disparity in fighting capability between the defender and the aggressor. We have an 84-year-old man, and any of you know who know 84-year-olds know that they tend to be pretty frail. And we have a 6-foot-tall 16-year-old. Apparently, from the defender's perspective, attempting to unlawfully enter Andrew Lester's home at 10 p.m. at night. So I would argue an 84-year-old under those circumstances, Ralph Yarl doesn't need a deadly weapon to cause death or serious bodily injury to an 84-year-old. Can we agree on that? And that's the definition of deadly force: death or serious bodily injury. So I think even under a self-defense analysis, you have a prima facie case that would meet your burden of production, allow that argument to be made in court, and have a compelling argument for the jury that the state would have to disprove beyond any reasonable doubt. But here's the thing, folks. Like most states, Missouri doesn't allow only self-defense as a justification, meaning defense of your person as a justification for the use of deadly defensive force. It also has a separate, parallel means of justifying the use of deadly defensive force, and that's defense of highly defensible property. Under Missouri law, that would include dwelling, residence, vehicle, occupied vehicle. And this allows you to justify your use of deadly defensive force without having to meet the elements of self-defense, because it provides its own set of conditions that, if met, justify that use of deadly defensive force. By the way, if you'd like this cheat sheet, we make this available for free. We don't charge a penny for it. It's just a PDF download. It's the 5 elements of self-defense, would also apply to defense of others, provides a brief description of each. If you don't understand these 5 elements, you can't possibly understand self-defense law, folks. This is how the legal analysis is done for defense of self and defense of others. And you can get this for free at lawofselfdefense.com/elements. See if I have a little banner for that. Well, I don't. But lawofselfdefense.com/elements will get you that cheat sheet. But here we're talking about the alternative to self-defense, the self-defense legal defense as a justification for Lester's shooting of Ralph Yarl. And that is defense of highly defensible property. Because as we scroll through this statute, 563-031, use of force in defense of persons, we get past the self-defense non-deadly force, we get to the self-defense deadly force, and then we get to this section, which collectively reads, a person shall not use deadly force upon another unless such force is used against a person who unlawfully or attempts to unlawfully enter a dwelling. And what matters here, as always in a use of force justification, is not what's actually happening. What controls here is the defender's reasonable perception of what's happening. Most of us saw the video of the Taqueria shooting in Houston, Texas, right? Where there's an armed robber waving a gun around. One of the patrons pulls his own gun, shoots down the armed robber. And I have my doubts about the final shot followed by that customer. But certainly the first 4 shots into the armed robber were completely legally justified, despite the fact that later it turned out, within moments, the defender would realize that the armed robber's gun was fake. It wasn't a real gun. The defender there shot the armed robber in the belief that the armed robber was presenting a deadly force threat to himself and other patrons. Was that true? No, there was no deadly force threat. In fact, there was no deadly force threat. The gun was fake, could not possibly have inflicted death or serious bodily injury on the patrons. Does that mean the use of deadly defensive force by the patron was unlawful? No, because what controls is not what's actually happening. It doesn't matter if there was actually a threat of death or serious bodily injury. What controls for legal purposes is, did the patron reasonably perceive that there was a deadly force threat? And certainly he and every other patron who was coughing up their money did reasonably perceive the fake gun as real. Here, the legal question is not, was Andrew Yarl actually attempting to unlawfully enter the home? That's not the right question. And if that's the question you're asking, you'll never get the right answer, legal answer. The correct legal question is, could Andrew Lester have reasonably perceived, under the circumstances, the totality of the circumstances, that Ralph Yarl was attempting to unlawfully enter his home? If the answer to that is yes, the shooting is lawful under Missouri law. because deadly force can be used to stop someone who's attempting to unlawfully enter a dwelling. Now, a caveat, because we have a factual dispute here. And the factual dispute is that Ralph Yarl, of course, was shot twice. Nobody contests that the first time he was shot, he was standing up, at least facing Andrew Lester's doorway. Lester says he was trying to open up the storm door of his home, which is the unlawful entry. And the only evidence against that is Ralph Yarl's own self-serving statement, right? They weren't able to exclude Ralph Yarl's fingerprints. There were fingerprints on the handle of the storm door that couldn't be matched to anybody, even Lester. They wouldn't match to Lester, the homeowner. So we can't exclude Ralph Yarl. And of course, remember, the state has to disprove Andrew Lester's story beyond a reasonable doubt. This isn't who do you believe more question. This is there even a reasonable doubt that Ralph Yarl could have had his hand on the doorknob? I certainly think there is. In any case, there's no question the first shot that struck Ralph Yarl was when he was standing up, because Ralph Yarl says, I was first shot standing up. He then says he fell to the ground and was shot while he was on the ground. We don't know if that's true. There's no corroborating evidence that I've seen. And there maybe such evidence will develop. For example, he was shot through the glass storm door. Now, I don't know. I looked for pictures of the storm door, and I can't find any. Now, it's one big sheet of glass, and it may have been completely shattered by the gunshots, and someone just swept up the broken glass, in which case we'll never have that evidence. It vaporized when the shots were fired. Or maybe there's a couple bullet holes in it, and it was collected for evidence by the police. That would be a reasonable thing for them to do. Although, honestly, as likely as not, they would have taken the whole door. But if it was collected in evidence, we may have one shot that's high up in the glass, horizontal to the ground, and another shot bullet hole that's much lower on the glass. That would be consistent with shooting Andrew Yarl on the ground. Or there may be forensics evidence. Although we only usually gather that kind of stuff in any specific way from corpses, not from living people. But there may be forensics evidence based on the nature of the wound to Andrew Yarl that would be consistent with him being on the ground when the second shot was fired. That would be a more difficult shot for Andrew Lester to justify. Certainly if he realized in the moment he was shooting someone on the ground, because then is there still an unlawful entry being attempted? A part of that would depend on the pacing of the shots, right? Some shots are fired very quickly. You don't have time to do a reassessment between them. If they're slow, spaced shots, the longer the spacing of the shots, the more time for reassessment, the more time to perhaps recognize that the attempted unlawful entry had stopped. Those would be openings for attack of the prosecution for that second shot. But for any shots that were fired horizontally in reasonably quick fashion, those are looked to be justified under Missouri law. As we see here, deadly force can be used to stop someone who's attempting to unlawfully enter a dwelling. Now, what this replaces is it replaces the need for a deadly force threat from Ralph Yarl. Any degree of threat would now be sufficient. Normally, if you were simply claiming self-defense to justify your use of deadly defensive force, you'd need to be faced with a deadly force threat. This provision takes away the need to demonstrate that you were facing a deadly force threat. When someone's attempting to unlawfully enter your dwelling, any reasonable perception of any degree of threat, which, let's face it, is baked into the cake when someone's unlawfully entering your dwelling at 10 p.m. at night, right? So that's what this provision does away with. All right. The next thing I wanted to touch upon was that news report. Let's take a look. Let's get back to good old Newsweek. I wonder what Newsweek's circulation is now. Oops. Last time I picked up that magazine, it was about 8 pages thick, and 6 of those were pharmaceutical advertisements. All right, back to this article. Ralph Yarl shooter using stand your ground defense is nearly impossible, says legal experts. Let's go find the legal experts. Here's one. Duncan Levin, a criminal defense attorney. Okay. He says stand your ground is going to be a nearly impossible defense to make. Again, stand your ground's not a defense, folks. The defenses here are either self-defense, and stand your ground simply removes what might otherwise have been the element of avoidance, a legal duty to retreat, or defensive dwelling. Those are the two defenses. There's no stand your ground defense. That's simply someone who doesn't understand these technical terms of art. He continues. Now, in fairness there's three attorneys quoted here. In fairness to them, because I've been interviewed and I've had my own quotes put incredibly out of context. So that could have happened here. So if Newsweek is misrepresenting what any of these lawyers say, I would apologize to them for the criticism I'm about to lay down, but you got to blame Newsweek. Sorry, folks. Sorry, fellow counselors. This is what you were quoted as saying, so this is what I'm responding to. If any of them feel they were misrepresented by Newsweek and would like to communicate that to me, I'd certainly be happy to communicate that to all of you. So stand your ground is going to be nearly impossible defense to make. It will be a nearly impossible defense to make because it doesn't exist as a legal defense. That's why it's impossible to make. He continues, to be successful, Lester will have to show that the victim, Ralph Yarl, was threatening him. And at least from what is publicly available, that does not appear to be the case. No, folks, if you're an 84-year-old man, 10 o'clock at night, you got out of bed to answer your door. And on the other side of that storm door is a 6-foot-tall male trying to force open your storm door. The threat of harm is baked into the cake. The only possible question would be, is it deadly harm? But the state of Missouri took that question off the table when they didn't require deadly harm, when they only required attempted unlawful entry as a justification for deadly defensive force. Essentially what the Missouri legislature was saying with that language is, we're presuming it's deadly threat if someone's unlawfully attempting to enter your home. So there is no need to show any deadly force threat. Any threat would be enough, and that's baked into the cake under these circumstances. Levin also noted that the available information indicates that Yarl did not enter the home, and Lester shot through the glass part of a locked door. Okay. I mean, it almost feels stupid having to do this, but the statute says it applies. Deadly force is authorized if someone unlawfully enters, remains after unlawfully entering, or attempts to unlawfully enter. There's no requirement that Ralph Yarl actually entered the home. The attempt, the apparent attempt, the reasonably perceived attempt is sufficient to meet these conditions. So poor Levin is talking about things he just doesn't understand. It doesn't matter whether or not Yarl entered the home. That's irrelevant to this legal analysis. But wait, there's more. Furthermore, to make out a successful stand your ground defense, there is no stand your ground defense. Lester would also have to justify why he shot a second time while the victim was already on the ground. Right, so I addressed this. That second shot could be more problematic for Andrew Lester. Maybe, maybe not, depends on the, what Lester has to say about it. Lester doesn't say he shot anybody on the ground. So this is a contested fact, a fact in dispute for the trial. Why he shot a second time while the victim was on the ground and clearly not a threat. All the public information is inconsistent with a successful stand your ground defense. No, it's not. You might dispute the analysis between the first shot and the second if you believe Ralph Yarl was shot the second time on the ground. But the information is not inconsistent with a successful defensive dwelling defense, stand your ground defense. Here's another lawyer, Niyama Ramani. If I'm mispronouncing that, I apologize. An attorney and formal federal prosecutor, wow, noted that all those states with stand your ground laws allow someone to use deadly force to protect themselves without having any duty to retreat. That's true. The force must be reasonable and proportionate to the threat. No, or at least alternatively, Missouri legislature passed a statute that says there need not be an actual proportionality of the threat. If it's merely self-defense outside the context of defending your dwelling, if you're just out on the street, yeah, before you can use deadly defensive force, you have to be facing a deadly force threat. But in the context of your home, it's sufficient to justify deadly defensive force that someone was attempting to unlawfully enter your dwelling. The unlawful entering of the dwelling is what meets the threshold for the use of deadly defensive force. But obviously, apparently, Attorney Romani didn't bother reading the actual statute. By the way, there's no reference to the actual statute anywhere in here. So nobody read it. Lester, she continues, must have reasonably believed he was at risk of death or serious bodily injury when he shot Yarl. No. The statute doesn't require that. For straight up self-defense out in the street, yes. In the context of someone unlawfully attempting to enter your dwelling, no. That's going to be a tough hurdle for Lester to overcome. Well, good news for Lester, he doesn't have to overcome it. At least not with respect to the first shot, for sure. Another attorney, Andrew Lieb, agreed. Missouri stand your ground law requires that Lester reasonably believes such force to be necessary to defend himself. Well, of course, the argument is that he's actually defending his dwelling. This situation, here comes the emotional legal analysis, folks. Always, I forgot to switch it over. Sorry. But Romani was just making the same point over and over again. Andrew Lieb, an attorney, says, stand your ground law requires that Lester reasonably believes such force to be necessary. No, what he had to reasonably believe was that Ralph Yarl was attempting to unlawfully enter his dwelling. If he reasonably believed that, the use of deadly defensive force is authorized under the statute. And now we get the emotional analysis from Andrew Lieb. I know we have 187 genders today. I'm presuming Andrew Lieb is a male by his name, but it doesn't look like it from his argument. This situation, quoting now, this situation is insane, and any thought of a defense based on this law is either a misreading of the law or a miscarriage of justice. Well, miscarriage of justice is an emotional argument, and he doesn't even reference the law. What law, Attorney Lieb? What law are you talking about? More emotion. Quote, I hope that even in your castle, someone ringing your doorbell could never create such a reasonable belief ever for anyone to shoot a kid in the head and then again when he is on the ground. Well, of course, it's in dispute that a shot was fired on the ground, as we've already discussed. And Andrew Lester is not justifying his shooting of Ralph Yarl because Ralph Yarl shot his doorbell. So that's simply a propagandized representation of the facts in the case. There's always this factual disputes, but a fair analysis looks at both of them, both sides of the argument. Andrew Lester's side of the argument is that he shot Ralph Yarl because he reasonably believed Ralph Yarl was attempting to make unlawful entry into his dwelling. And he was an 84-year-old living by himself and would have no chance against a 6-foot-tall male, young male, if that male was successful in his apparent attempt to unlawfully enter the home. We'll get to that in a moment. We're going to look at the probable cause statement here too. Andrew Lieb says, simply, if you don't want to do the time, don't shoot people who ring your doorbell. I mean, this is just a disgusting and disingenuous representation of the facts. Maybe he doesn't know any better. Maybe he's providing this legal insight based only on the propaganda he's seen in the media. But you know what? He's supposed to be a professional. It's really contemptible. Contemptible. Now, there were a couple things there. People talked about whether or not those legal experts suggested that Andrew Lester would have needed to have been facing a deadly force threat in order to be justified in using deadly defensive force. And I've argued that's not the case, that the Missouri statute doesn't require that it replaces the deadly force threat requirement with the unlawful entry into the home requirement. If there's an unlawful attempt to unlawfully enter the home, that triggers the justification for deadly defensive force without the need for showing that there was a deadly force threat. But Andrew, there are 3 legal experts. They disagree with you. Maybe they're right. Maybe they are. How about we take a look? And I took a look. And what I found was this Missouri Supreme Court decision, State v. Strotter. I've already put the link to this in the description for today's show, or you can just point your browser to lawofselfdefense.com/Strotter. Missouri Supreme Court. So laws come from really 2 places, right, in American society: statutes, which we've already looked at, and then there's case law, appellate court decisions, the courts that interpret and apply those statutes, and whose interpretation and application is really what determines what the statute means. So if the Missouri Supreme Court disagrees with what I think is a plain English reading of the statute, well, then my plain English reading is wrong, because what controls is what the court says. The appellate courts, and ultimately, of course, as here, the Missouri Supreme Court. So what does the Missouri Supreme Court have to say about this defensive dwelling provision? Missouri Statute 563.031, Section 2.2. This case involves that statute. And by the way, I would note that this opinion was handed down less than 1 year ago. Now, case law is valid unless overturned or distinguished, even if it's very old. But it's particularly compelling when it's new. And this is new, less than a year old. By the way, this was a 6-1 decision. There was a dissent, but the dissent did not disagree in any way that would change our analysis here. It disagreed on a completely unrelated legal argument. Essentially, the dissent disagreed because the dissent doubted that the unlawful entry and the defensive use of force were close in proximity to each other in terms of time. The dissent believed that a reasonable jury could have concluded that, sure, there was an unlawful entry, but the use of force happened much later, and therefore one can't justify the other. That was the dissent. We don't have that issue here in the Andrew Lester, Ralph Yarl case. So even though there's a dissent here, it's on a completely irrelevant issue for our purposes. So for our purposes, this is a unanimous 7-0 Missouri Supreme Court decision on the question of defensive dwelling, and whether, if you're defending your dwelling against attempted unlawful entry, you need to be facing a deadly force threat, as those 3 legal experts claim in the Newsweek article. Now, I'm not going to read through all the facts here. It involves someone who's in their vehicle and they were attacked, and there was an unlawful entry, an attempted unlawful entry, and then they shot their attacker. The relevant part, however, I just took quotes out here. And again, you can read that whole decision for yourself. It's in the description. But the relevant parts are here. And again, State v. Strotter, Missouri Supreme Court, April 26, 2022. Quote, Missouri law also recognizes, in addition to a self-defense justification, what is commonly known as the Castle Doctrine. All right, I want to pause right here for a second. I hate it when they do this. They're using the phrase Castle Doctrine here in a much broader manner than I like. Historically, the Castle Doctrine did one thing. It relieved you of an otherwise existing legal duty to retreat that might have applied if you were outside your home in the street. It relieved you of that duty to retreat if you were inside your home. That's all. That definition of the Castle Doctrine applies in every single one of the 50 states. Now, different states also do things like adopt special provisions for defensive dwelling, provisions that change the requirements for the use of deadly force in defensive dwelling to be lawful. And different states adopt different types of provisions with different conditions. So those are all different across the 50 states. Now, within each of those states, they tend to also call that Castle Doctrine. And that's what this court is doing here. Now, that's not harmful or confusing if you're only working within one jurisdiction, which is what the Missouri Supreme Court is doing. It's only working within Missouri. So if they use a broader definition of Castle Doctrine within Missouri, and it's consistent with Missouri law, nobody gets confused. But the moment you take that definition of Castle Doctrine and attempt to apply it in Nebraska or Utah or Colorado, you're using the phrase Castle Doctrine in a different jurisdiction where it means something else. And that creates confusion. And of course, all my content goes out to people in 50 different states. So I don't like to use the phrase castle doctrine more broadly than the historically correct definition of relieving you of a legal duty to retreat. That caveat out of the way. Here, this Missouri Supreme Court is using castle doctrine to mean not only no duty to retreat in your home, but also this special provision for the use of defensive dwelling against attempted unlawful entry. All right. So broader than I would like, but accurate under Missouri law. So, quote, Missouri law also recognizes what is commonly known as the castle doctrine, codified in section 563.031.22. That, of course, is this provision that we've been looking at. This is 2.2. Deadly force, permissible, privileged, legal, when you're using it to stop an attempted unlawful entry into a dwelling. Under the castle doctrine, a person need not face death, serious physical injury, or any forcible felony to respond with deadly force. Well, that's it, folks. That's the answer. Did Andrew Lester need to be facing a deadly force threat if he reasonably believed that Ralph Yarl was attempting to unlawfully enter his dwelling? No. No, he did not. Under the castle doctrine, 563.122, a person need not face death, serious bodily injury, or any forcible felony to respond with deadly force. If there is the attempted unlawful entry, that is it. That is all that's required. And arguably on the facts, we have that here. So let's take a look at the probable cause statement. Now, when I read this probable cause statement, I have to say, and it's not the first time I've seen this, it's written as if it was going to conclude that no charges were appropriate. Because there's certainly facts in this statement consistent with a prima facie, at least a prima facie case for defensive dwelling here. And remember, the burden is not whether or not you think it's more likely than not in Andrew Lester's favor. The question is, can the state reasonably disprove this beyond a reasonable doubt? I'll also note that you won't find a hint here of any evidence of racial motivation, racial animus, anything. And this is after the police were given permission by Andrew Lester, no warrant required, written permission to search his house. No Confederate flag t-shirts from a Lynyrd Skynyrd concert, nothing. Nothing to suggest any of that. Despite that, the prosecutors talking to the media saying there's racial elements to this shooting. Despicable. All done simply to racially energize the case. To propagandize the jury pool, to make it impossible for Andrew Lester to get anything like an unbiased, impartial jury when he goes to trial. The facts supporting what they believe are the criminal charge here of aggravated assault. On April 13th, at approximately 21:52 hours, so 8 minutes before 10 p.m., the police were called. They were dispatched to the home for a shooting. Upon arrival, they found PY. Every reference here to PY is Ralph Yarl. I don't know why they call him PY. RY, I guess, would be appropriate, but maybe just miscommunication. And they don't identify him by name, in this document, presumably because he's a minor. They identified him in the street in front of an address. He'd been shot. Medical personnel on the scene said he was suffering serious injuries, was in stable condition. Okay, that's all fine. They were contacted by a party who called 911, stated they believed the person who was shot was at another address. They approached the address and observed the front storm door glass shattered with a man standing inside the residence. Officers gave the male, later identified as Andrew Lester, verbal commands to exit the residence, and he complied and exited the rear of the residence. So another thing to note, Andrew Lester was completely compliant at all times with law enforcement, as was Kyle Rittenhouse, as was George Zimmerman. Lester provided a written consent to search his residence. Do I recommend that? Not particularly. Certainly you have the right to demand that the authorities secure a search warrant. That said, and mostly not because I think you would have done anything wrong in whatever your use of force event is, but folks, most of you don't know the unbelievable variety of things that you may be engaged in without having any idea that they're actually crimes, potentially serious crimes. Something as simple as having prescription medicine and moving it from the jar it came in from the pharmacy into some more convenient container is a crime. There's thousands of things that are crimes. You have no idea. But if the authorities are looking for something and they have free access to your home, especially if they didn't have to get a warrant, which would limit what they were able to take as evidence, secure as evidence, you could find yourself facing charges for all kinds of things. Okay, so, but anyway, he didn't worry about that. He said, no, it's fine. I'll sign this little notice. You have permission to search my home. They went through the house, consent to search form. And this is now the all this first person pronoun stuff. Hey, pronouns in a law of self-defense show is the officer who signed this, Detective Dennis Paquette. I observed the front storm door glass broken. Now it says broken, not shattered. So I wonder if the glass is intact with a couple bullet holes in it, right? That's not uncommon for bullets just to leave a hole in glass and not explode it out. That would be nice. That would offer us some, should be pretty decisive evidence in terms of angles of fire to corroborate or not this claim by Ralph Yarl that he was shot while he was on the ground, the second shot. I observed the front storm door glass broken with blood on the front porch. I observed blood on the driveway. I observed cameras around the house. These were connected to a security system that was inoperable, unfortunately. So all this blood's outside, and you'll hear people in the media say, see, there was no blood inside the house. All the blood was outside. Ralph Yarl never entered the home. Is it required that he enter the home, folks? Or is it sufficient under Missouri law that he attempted to unlawfully enter? More important, that he was reasonably perceived by the defender, mistakenly or not, as attempting to unlawfully enter. So, a witness was interviewed who stated that at approximately 10 minutes to 10, they heard an unknown vehicle pull into the driveway of the defender's home. The witness thought it was odd for their elderly neighbor to have a visitor this late at night. So that was not normal. That was cause for concern, cause for alarm, especially not just by the neighbor whose house it was not occurring to, but to Andrew Lester, 84 years old, living alone, in bed. And then he has to answer his front door at 10 p.m. at night when that's far from a normal circumstance. The witness stated a short time later they heard 2 to 3 gunshots. Yeah, the witnesses never accurately remember the number of shots. The witness stated after the gunshots were heard, the Ralph Yarl was screaming that he had been shot. The witness observed Ralph Yarl knock on neighbors' doors asking for help. The witness did not see the shooting. So an ear witness to the shooting. Crime scene personnel responded and processed the scene at my request. They photographed the interior of the residence. They located a Smith & Wesson .32 caliber revolver in the front living room chair with 2 spent shell casings still in the cylinder. So I think it's fair to say only 2 shots fired, along with live rounds in the remaining chambers. Crime scene also located a Bunker Hill security wireless surveillance system receiver in the northeast bedroom hanging on the wall behind the house. So Andrew Lester was concerned about crime around his home. After crime scene personnel photographed the security wireless surveillance system, I removed it from the wall, took custody of the hard drive to preserve any video. Upon reviewing the footage of the system, it was determined that the system was no longer functional. The last captured event was dated June 25th, 2022. So almost a year ago, the system stopped working. Folks, I'm a big advocate for these camera systems outside your home. They don't reportedly do much to deter actual criminals who tend to get in and out before you can have an effective response based on the camera system. But they can be useful for providing corroborating evidence consistent with self-defense, such as whether or not Ralph Yarl was on the ground when he was shot the second time. So it pays to keep these things working. To the extent everything has an app today, and I wouldn't expect it, let's face it, my dad's 83 years old. I wouldn't expect him to know how to use a security camera app. But it can also be useful for you to check around what's happening outside your home on your smart device before you open your front door at 10 o'clock at night. And it can be very useful to have cameras from more than multiple angles. At my home, for just the front door, we have, for example, the doorbell camera facing out, but we also have a camera behind whoever would be at the front door. So I can see the exterior sides of my door. I can see what the person might be holding behind their back via the cameras. So stuff to think about. Of course, folks, the cameras are most helpful to you if you know what you're doing in self-defense and stay within the legal boundaries. If your cameras record you doing it wrong, that will be incriminating evidence. On April 3rd, the same night, 23/22, so now 11:30 at night, this 84-year-old man, 11:30 at night, arrived at the police department to provide a recorded statement. Never do that, folks. And he doesn't have a lawyer here. What kind of recall you think you're going to have an hour and a half after you've shot someone, 11:30 at night? You think the cops who are questioning you at 11:30 at night, that they woke up and came to work at 6, 7 a.m. that morning? No, folks, it's a different shift. These people are fresh. Your interrogators are fresh. And this is a normal day for them. This is not a normal day for you. And you're probably exhausted, even besides the stress of having to defend yourself with deadly force. He was read the Miranda warning, and he stated he understood his rights and agreed to give a statement. Completely voluntary, no lawyer, no holding back. And this is where we get the facts to see if they support a reasonable perception. Doesn't have to be a correct perception. Doesn't matter if Ralph Yarl was actually trying to unlawfully enter the home. What matters is there a reasonable doubt that Andrew Lester could have had a reasonable perception that Ralph Yarl was attempting to unlawfully enter the home? If so, the use of deadly defensive force was justified under Missouri law. Lester stated he currently lived at that home. On April 13th, he had just laid down in bed when he heard the doorbell ring. Lester stated he picked up his gun, a .32 caliber Smith & Wesson revolver, before responding to answer the door. That's just prudent, folks. Of course, you don't have to answer the door, but it's normal human behavior to answer a doorbell. That's why you have a doorbell. But if it's ringing at 10 o'clock at night, maybe bring a pistol with you, right? Just in case someone tries to unlawfully enter. By the way, someone just sent me video footage this morning of just such an unlawful entry. Someone rings the bell, they pretend they're delivering a package, and then they try to bull rush their way into the door when the homeowner opens the door, gun in hand by the bad guy. This stuff happens all the time, folks. This is a legitimate concern. He stated the front door of his residence consisted of an interior main door, that's a wooden door, and exterior glass storm door, both of which were locked. Now, first of all, this is a question, right? So he may tend to keep the doors locked, but we all make mistakes. You don't actually know in the moment if it's locked until you try it and see if it's locked, right? So the wooden door, he would have had to, if he had to unlock it to open it, then he knew for sure that was locked. The storm door, how many times have we wondered, did I lock that door after we've left home? The storm door, it's generally locked, but he wouldn't know for sure until it was tested, right? Lester stated he opened the interior door and saw a black male approximately 6 feet tall pulling on the exterior storm door handle. Now, in Ralph Yarl's mind, is there an explanation consistent with innocence for why he might be doing that? Sure. Maybe Ralph Yarl had rang the doorbell, was taking a long time for anybody to answer the door, and he thought, maybe the doorbell's broken inside the house. Maybe it doesn't work. Sometimes doorbells don't work. I'm going to knock on the wooden door to see if they can hear that. And to get to the wooden door, I need to open up the storm door. So he's working the handle to try to get the storm door open. And folks, we all have storm doors. We've had ones that stick, right? Aren't always the easiest to open. So you might try the handle a couple times. in all innocence, simply for the purpose of being able to knock on the wooden door. But if in that moment, while Ralph Yarl is working the door handle, trying to open a storm door, if in that moment, that's the moment when Andrew Lester opens up his wooden door, 84-year-old Andrew Lester, living alone, 10 p.m. at night, sufficiently concerned about his safety that he brought a gun with him to answer the door, that he has a security system, however inoperable, installed around his house. If that's the moment when Andrew Lester, under those circumstances, opened his wooden door and saw a 6-foot-tall man apparently attempting to open his screen door and unlawfully enter his residence, would that trigger the provisions of 563-03122, use of deadly force in defense of someone reasonably perceived as attempting to unlawfully enter a dwelling? On these facts, can the state really disprove that beyond any reasonable doubt? Now, again, we do have the question of the second shot, right? So I've already mentioned that. Lester stated he believed someone was attempting to break into the house and shot twice within a few seconds of opening the door. Now, the number of seconds could matter, right, with respect to that second shot. Lester stated that a male ran away and he immediately used his home phone to call 911. Remember one of these legal experts saying that there was no evidence that this one, Levin, what's your first name, Levin? Duncan Levin. It also appears that Lester did not call police, Levin said. So this guy is providing this legal insight without even having read the probable cause statement, because the probable cause statement never contests that Lester called 911. And it certainly would do so if that was the case. Just contemptible. Really, that's why people don't like lawyers. Lester stated he observed a car in the driveway he believed to be the male's vehicle, but did not see anyone else in or around the vehicle. By the way, very, very common, folks, in these home invasion scenarios, that one person approaches the door to get the homeowner to open the door, rushes in, and then the car they came in has 4, 5, 6 other people in who follow. They don't put all 5, 6 people at the door before it opens because that would obviously be threatening to the homeowner. So they send one person up to bull rush the door, and then a bunch of people swarm in from the car. Very, very common. Something Andrew Lester may have been concerned about. Lester stated that he had never seen the male before. He stated no words were exchanged during the incident. Of course, no requirement for that, right? Before you can defend yourself. And the male had not said anything prior to pulling on the door handle. So Lester is very, very consistent here on the pulling of the door handle. Lester stated it was the last thing he wanted to do, but he was scared to death due to the male's size and Lester's age, 84, and his inability to defend himself. Is that consistent with our common sense and life experience that it would be hard for an 84-year-old to defend themselves against a 6-foot-tall young male? I think so. By the way, how different is this than the Michael Draka interview? Remember Michael Draka, the handicap parking spot case? He shot Marcus McLaughlin, dead, got prosecuted. He gave an interview to the police also without a lawyer present. But Michael Draka, his presentation, his demeanor in that interview was righteous. He was, and I'm not saying that's a moral offense. He was being questioned by the police, and he might have realized they were trying to, they were doing their job. They were trying to gather evidence to see if they could charge him with a killing offense. But he came across as extremely defensive, righteous, justifying his use of force. It didn't look good when those videos were played in court, folks. He didn't come across as at all sympathetic to Marcus McLaughlin. He came across as basically saying, hey, that guy earned that shooting. And you might really feel that way, but I can tell you it doesn't look good to the authorities, and it doesn't look good to a jury. How different is Andrew Lester here? He said it was the last thing he wanted to do, but he was scared to death, subject to fear of harm, due to the male's size and Lester's age, 84, and his inability to defend himself. He believed he was protecting himself from a physical confrontation and could not take the chance of the male coming in. What chance would 84-year-old Andrew Lester have had if Ralph Yarl had made it into the house? And again, it doesn't matter if Ralph Yarl was actually trying to come to the house. It matters whether Andrew Lester could have had a reasonable perception that could not be disproven beyond a reasonable doubt that that's what Ralph Yarl was trying to do when he was working the door handle of that storm door. Lester was visibly upset and repeatedly expressed concern for the victim. So far, I would suggest that this is very favorable to Andrew Lester, this probable cause statement, that they've used as the basis to charge him with a life felony. Concluding the interview, Lester was transported to the police department where he was booked, photographed, fingerprinted for charges of aggravated assault. And then they released Lester pending further investigation. And why not? I mean, this guy's not a threat to anybody. If you don't present as if you're trying to unlawfully enter his home, they know where to find him. Where's an 84-year-old going to go? I mean, it's not exactly Bulger. It's not Whitey on the lam. The same day, detectives responded to the hospital to contact the victim, possibly get a statement. They were unable to do that due to the victim's injuries, reasonably enough. They went back to hospital the next day. Ralph Yarl was undergoing medical treatment. They did, I guess, a cursory interview. Ralph Yarl says he was told by his mother to respond. By the way, none of this stuff, why he was actually there, I'm more than ready to assume this is all true. And Ralph Yarl was acting with the best of intentions. I've seen no evidence to the contrary, right? New evidence changes the analysis. But as far as I know, Ralph Yarl was acting totally innocently here. Does that do anything to undermine Andrew Lester's justification? No. Because what controls Andrew Lester's justification is his reasonable perception of what was happening, not what was actually happening. How could Andrew Lester know any of this? Nobody acting in defense of themselves or their home could possibly know any of this, that Ralph Yarl was sent by his mother to pick up his twin brother someplace and just went to the wrong address. He stated he pressed the doorbell and waited outside the front door. He stated the mail inside took a long time, but finally opened the door holding a firearm. So even Ralph Yarl says it took a long time. Is it taking a long time for Andrew Lester to get to the door? Is that consistent with the notion, with what Andrew Lester said, that Ralph Yarl was working the handle of the storm door, maybe for innocent purposes, maybe so he could knock on the wooden door when he wasn't getting a response to the doorbell? It's all consistent with Andrew Lester's story. Ralph Yarl stated he was immediately shot in the head and fell to the ground. Ralph Yarl stated while on the ground, he was shot a second time in the arm. By the way, can we be certain Ralph Yarl knows when he was shot? You would think so, but I can tell you, folks, under this kind of stress, and we're assuming for discussion purposes that Ralph Yarl had nothing but the most innocent intent here, and suddenly he's finding himself being shot. Recollection under those circumstances is worse than imperfect. It can often be catastrophically wrong, especially just a day after the event. Ralph Yarl advised he did not pull on the door, and this was his first time coming to the residence. He stated he got up and ran away to keep from being shot. Ralph Yarl stated the mail, stated Andrew Lester said, "Don't come around here." I mean, is that an unreasonable thing for Andrew Lester to say if he reasonably believes he just had to use deadly force to drive off a home invader? I think that's mild language. It's certainly not the N-word, is it? Ralph Yarl stated he went to multiple residences looking for help. He had suffered a gunshot wound in the left forehead and the right arm. I received a lab report. This is the detective now, Parquette. I received a lab report, DNA from the blood, recovered from the exterior storm. There were DNA swabs from the exterior storm door of the residence. 2 contributors with 1 major contributor. The DNA recovered from the blood, so that would be Ralph Yarl's, was not a major contributor, but it could have been a minor contributor then. On April 17th, I was contacted by the lab and had the fingerprint recovered from the exterior of the storm door, excluded Lester. That's the homeowner. So he didn't have a match on his doorknob, which frankly doesn't surprise me. I mean, a lot of homes, my own home, I go in and out 99.9% of the time through the garage door, not the front door of my home. Other people's fingerprints are going to be much more common on the exterior front door of my home than will be my fingerprints. But fingerprints of the exterior or the front storm door excluded Lester, but it doesn't say it excluded Yarl. Then there's a lot of discussion here about them trying to get a more formal statement from Yarl and being unable to do it. And listen, in fairness, that could have just been miscommunication or because of his injuries or who knows. But of course, this was also the time that Benjamin Crump and Lee Merritt, the propagandist, racial arsonist, civil rights lawyers, were coming on board to represent the family. By the way, I've heard their GoFundMe is now in excess of $3 million. I saw this morning. And there's the signature by the detective. So that's where we are with all of this. Certainly, I think there's more than enough facts and evidence to sustain a legal defense of dwelling under Missouri law against any attack by this prosecutor, because you'd have to disprove that defense beyond any reasonable doubt. And I don't see that on these facts, with the caveat that it becomes a more difficult, not by any means impossible, given the Andrew Lester's age, lack of tactical training, the heat of the moment, the rapidity of the shots fired if they were fired rapidly. But it becomes a more difficult defense if the second shot was fired into Ralph Yarl while he was laying on the ground. But that claim's so far uncorroborated, right? Lester doesn't say he did that. So we'll have to see. So certainly for the first shot, easily defensible under Missouri law. Easily. Not difficult. Easily. The second shot, more complicated. Now, some people did ask me about another unrelated case. Happened to take place, I believe, the day before this shooting. It was in upstate New York. A man charged with murder for shooting a woman who drove down the wrong driveway. This occurred in upstate New York. And a woman and some friends in a car were driving around in this. And if you've never been to upstate New York, it's the country, folks. There's a lot of dirt roads. There's poor cell reception. It's easy to get lost. It's especially at night. It's dark. It's really dark. I mean, it's so dark that like the delineation between what your headlights illuminate and 6 inches over is black and white. You can't see anything to the sides. So it can be very, very confusing at night. And this woman was out with a group of friends looking for another friend's house at night on a Saturday, and they went up the wrong driveway. And it's as the car approached this guy's house, the homeowner's house, the homeowner stepped out of his house and fired twice at the car. And then I believe he fired more at the car as the car was leaving. They're a little vague about that. But the car is pulling up to the wrong house, coming up the dirt driveway, and this guy steps out of his house and just shoots twice into the car, mortally wounding this girl. So how do we distinguish that case from the Lester Yarl case? Well, in the Lester Yarl case, the evidence is, now, of course, it'll be contested, but the evidence is that Ralph Yarl was working the doorknob of the storm door. That's what you do to enter a dwelling. He's making affirmative, physical, overt physical acts to carry out the process of entering the home. A car merely pulling into your driveway is not doing that. There is no evidence from which you can reasonably infer an imminent threat or imminent intent to unlawfully enter a dwelling simply because a car is rolling up your driveway. That's the difference here. And of course, they never came close to actually attempting to enter the driveway. I mean, you have to be doing something, right? Working the doorknob of a house, sure. Inside a car that's rolling up a driveway, there's no imminent unlawful entry there. Can't be reasonably perceived. So yeah, it looks like this guy was just some kind of wacko. Certainly had not attended a law of self-defense advanced class, that's for sure. And has been charged with murder. And looks to me on this reporting like it should be murder. I don't see any alternative explanation. Okay, so let's turn to questions. Questions. As always, we start with the Law of Self-Defense members who get to answer their questions. I get to ask their questions for free, folks. The rest of you, if you'd like to pose questions for me to consider, if you're watching on YouTube or Rumble, that's great. I encourage you to do that. It is a $5 minimum YouTube super chat or a $5 minimum Rumble rant on either of those platforms. So if you're just in the chat, I'm not even going to see it, folks. And if it's $1.99, I'm not going to read it. So it's got to be $5 minimum. Or you could be in the Law of Self-Defense member chat where we stream this show live as well and ask all your questions there for free. And membership only costs about 30 cents a day, folks, less than $10 a month. And you get all your questions answered for free. You can become a member right now at Law of Self-Defense at lawofselfdefense.com/join. Okay, let's see. They're now trying to get the feds involved over an accurate description of the intruder. Why? Because the homeowner described him as black. That happened with Zimmerman, right? They edited Zimmerman's 911 call to make it sound like George Zimmerman spontaneously offered up that Trayvon Martin was black, as if he had racial motivation for doing that. When in fact, when you listen to the entire 911 recording, the version not edited by the media, Zimmerman's simply responding to a request for a description from the dispatcher. Was that guy white, black, or Hispanic? And Zimmerman goes, he looked black. That's it. Zero racial animus. Someone asked how far away are the two different addresses, the address where this occurred and the address that Ralph Yarl was supposed to have gone to. I have no idea. Someone says the homeowner was filmed cleaning up the glass the day after the event. No police crime scene tape anywhere. Well, maybe there was nothing to preserve. You know, if the storm door was completely shattered, there's really no point to the police. I mean, what would they do with it? A pile of broken glass. But if the police failed to secure the sheet of glass with discrete bullet holes in it, that would go against the police. Again, the burden's on them. The burden's not on the defense. Law of Self-Defense member Tony says, question, do attorneys quote statutes to jurors during the trial? Well, they can. They can put them up like in a PowerPoint. You'll see that sometimes. Usually they'll use the jury instructions. The jury instructions tend to be a plain English language version of the statute that also incorporates like case law language, like how the courts want to. You can think of the jury instructions as an amalgamation of the statutory language and the case law together in plain English. And of course, the jury would be instructed on that. But yes, the either party can put the jury instructions up for sure during closing argument. Law Self-Defense member Blake says, what relevance could no trespassing signs have on the situation? Well, we have to be careful there because it's up to us not to be misleading about the facts either, right? To be properly informed. I've heard there were no trespassing signs, but all I've seen in photos is next to the front door is a no soliciting sign. And no soliciting is different than no trespassing. No trespassing says you're not allowed on the property. You don't have license. No soliciting says you're not allowed to bother me, but you can come on the property like to leave a package, but you can't come on the property to solicit work. So it's a very different thing. And you know, when you have a front door and a doorbell, there's an implicit license to come on the property. That's why the doorbell's there, right? You haven't set up a gate. You're just open access to your doorbell. That's the purpose of the doorbell. So there's an implicit license that you're permitted to approach the doorbell. If you don't have a gate, if you don't have no trespassing signs up, and all I see is no soliciting, not no trespassing. There's a second sign that says security cameras in effect or language like that. But again, that doesn't say you're not allowed on the property. It just says if you come on, be aware that you're being filmed. So I'd be careful. If there was a no trespassing sign, that would override the implicit privilege to come on to ring the doorbell. But at worst, it would be what I would call simple trespass, probably what Missouri calls second-degree trespass. So it wouldn't be a crime. It would be like a ticketable offense. It wouldn't be a crime until you were personally informed to get off the property. Then it becomes a crime if you don't leave when you're informed. Let's see. Jack, law self-defense member Jack says, could both combatants qualify for self-defense? Yeah, they could, arguably. So say Andrew Lester was slow bringing his gun up, and Ralph Yates had his own gun. And he thought, holy cow, I'm about to get shot by this guy for no good reason, that Ralph Yarl would know. And Ralph pulls his own gun and shoots Andrew Lester. And then Ralph Yarl would say, well, heck, I had a reasonable perception that I was about to suffer, a non-justified imminent threat of deadly force harm from Ralph's perspective. Yeah, that's exactly the argument Ralph would make. Now, of course, we saw that argument recently, didn't we? In the Dean Anderson trial, right? Dean Anderson, police officer, investigating a burglary around a woman's home. At night, she saw lights outside her home. She got her own gun, pointed it out the window. Officer Anderson saw her gun, shouted, drop it, shot and killed her. He just got convicted. That was his legal defense, was self-defense, that he was defending himself against the gun inside the home. Frankly, I think that should have been an effective defense, but he was convicted regardless. Let's see. Law self-defense member George from Orange County, New York. Have I seen the most recent report that the New York shooter was shooting shotgun slugs? No, I haven't. It doesn't really matter what he was shooting. For legal purposes, it doesn't really matter. All gunshots are deadly force. So, law self-defense member Kolkami Sumil, sorry if I'm mispronouncing that, asks, if we get injured in a self-defense incident, does our employer sponsor health insurance? I don't do health insurance law. I'm sorry. I don't know anything about that. But yeah, I would think health insurance would cover you for traumatic injury, but I don't know. It depends on your policy. Let's see. Law self-defense member Jack Griffith says the two addresses were a block apart. So yeah, I think, where is that? Where's the probable report? So I think, well, I don't know. In the probable cause report, they described the addresses as Northeast 115th Street. I thought I had seen in news reports they were described like terrorist plays. Two different names that were very similar to each other. But in any case, I'm more than willing to believe that the community was an easy one in which to get lost, where lots of homes looked alike. I mean, that's not uncommon in neighborhoods. So again, I'm more than prepared to believe, based on the evidence I have, that Ralph Yarl was acting completely innocent and with no malicious intent whatever. Wouldn't surprise me at all. Oh, Aaron Dean. I'm sorry, the police officer I was just describing. That was Aaron Dean, not Dean Anderson. My apologies. If I'm able to disclose, what are some cases that you have served as an expert witness and counsel for? So I'm not generally an expert witness. I mean, I've never been an expert witness at trial. I'm an expert legal consultant. So generally, my work product is a very comprehensive report of legal analysis that I provide to the defense team, and they use that to convince the prosecution to dismiss the charges or put the client into a diversion program. Those are the most common outcomes we get. I generally don't talk about the cases in any detail, because these are the cases I work on are normal law-abiding people who've never been in trouble with the law a day in their lives. Generally, they were charged with killing crimes. I'm expensive, so normally I'm only retained for manslaughter or murder cases. And they're looking at 20 years to life in prison. And we generally, almost always, get the charges dismissed or a diversion program. And these people suddenly get their life back. They don't want me talking about their case in public. So with very rare circumstance, I only talk about them in the most ambiguous of terms. I mean, I can tell you I've worked murder cases. I can tell you I've worked a lot of aggravated assault with deadly weapon cases. But I'm really not going to get into detail that would reveal, that could be matched to media reports that would reveal who these people are or where this occurred. The best way to get a sense of my legal expertise is not for the privileged work I provide for clients, but the stuff I do every day here, which is fully exposed to the public in every every other lawyer out there. And they're free to argue against my analysis of my positions and come to your own assessment of who do you think is doing a more compelling job at that. Oh, by the way, I did hear someone informed me that I believe about an hour ago. It was about an hour ago in real time. So right now it's almost 2:30 Eastern time. About an hour, I think it was about maybe now, but right around this time that Andrew Lester was being arraigned in court, that he was going to be offered a $200,000, something on that order, bail. See if I can. Let's see. $200,000 bond offer with, of course, electronic monitoring if he can post the bond. I mean, really no reason to release this. Where's he going to go? 84 years old. And that was at 1:35 p.m. today, but I don't know what, let's see. Time zone is Missouri. Right now, it's about to happen. His arraignment is about to happen. I don't know if that'll be live streamed or whatever. Usually not much happens in the arraignment. That would be different from the probable cause. They're very rubber stamp kind of affairs. Basically, do you understand the charges against you? Yes, I do. How do you plead? Not guilty. As of the record, in the docket, as of this morning, there was no lawyer listed for Andrew Lester, but hopefully he shows up with one. That would be prudent. And that's all the the law self-defense member questions. Let me take a look at now the super chats, see if any have come in, see if anybody paid to yell at me. Let's see. Fury Patriot, $5 super chat. Thank you very much. Says the only racial factor here in this case is grifter Ben Crump. Yep. Law self-defense YouTube. Ethan Dad 3D, $5 super chat. Thank you very much. Says, is there a corresponding law that you can't attempt to operate someone's storm door without being invited? I've never heard of such a law. So, and that's it for super chats. And let's take a look if there's any Rumble rants. All right. There aren't. So I think I've covered everything I needed to say. Again, folks, if you like this legal stuff, and obviously a bunch of you do. Oh, if you're on YouTube, please subscribe. If you haven't, hit the thumbs up. If you could leave a comment, even if your comment is just your city and state, that's always appreciated. It helps fool the algorithm. But definitely subscribe. We're getting close to some kind of threshold here on YouTube, close to 50,000. It would always be nice to cross that threshold. Same on Rumble. Please subscribe, thumbs up, leave a comment. Even if it's just your city and state, that's always much appreciated. And if you like this legal stuff, and obviously you do, you're here, you might consider taking a look at our very popular and well-reviewed Law of Self-Defense American Law courses at AmericanLawCourses.com. These are law school level courses in criminal law, evidence, property, this summer semester, constitutional law, and many more subjects taught at the law school level, but at a fraction of the time and cost commitment of law school, and most importantly, without any of the political toxicity of today's law school. We just teach traditional American law in the traditional American way, and we have a wonderful panel of very, very talented and knowledgeable instructors. So if you'd like to be the best American citizen you can be by being actually informed on the actual law at the same level that lawyers are taught this stuff in law school, then I would encourage you to take a look at AmericanLawCourses.com. All right, folks, if there's nothing else, I will wrap this up about an hour and a half in. I remind all of you that if you carry a gun, own a gun so that you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until we meet next time, probably tomorrow, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.